Hi, welcome to my channel and please don't forget to like, comment and subscribe. Today I bring a topic about Case Maritime Law Herculito Maritime Ltd and others v Gunvor International Boulevard and others or the Polar Court of Appeal 2021. On general average, piracy owners seeking to recover ransom payment from bill of lading holders. This is a court of appeal decision following the cargo interest appeal of commercial court decision that was issued in 2020 in favor of the owners. The main question was whether the cargo interests were liable to contribute towards general average or GA. On appeal, the cargo interests argued that the owner's agreement in the charter party to claim exclusively under their insurance for the cost incurred following a seizure by the pirates was incorporated in bills of lading, and, if necessary, the terms of bill of lading should be manipulated to impose an obligation on the cargo interest to pay jointly and severally any additional premium for the level required by the charterers. On the other hand, the owners argued that the term in the charter party only amounted to an agreement by owners not to seek contribution for GA from the charterers. And also, number two, if the owners intended to waive their right for contribution under GA from another party, clear words of intention were required. And then, Court of Appeal decision. The Court of Appeal found in favor of the owners and dismissed the appeal. It held that the incorporation of the terms of the charter party into the bills of lading is a question of a construction and business common things and common sense must be applied. And then number two, although the term obliging charterers to pay for the K&R premium was directly relevant to the contract of carriage and therefore would be incorporated in the bill of lading, it would not justify a manipulation such that it would extend owners' agreement to waive rights to claim a GA contribution for cargo owners. And the third, in the absence of the express words of rebuting the presumption that the owner did not intend to abandon its right to a contribution from the cargo owners in GA meant that the cargo owners and their insurers could not escape liability for risk that they had assumed. And then for the next is the comment for the netizen. The decision provides a useful reminder on the court's approach to the incorporation of the charter party terms into bills of lading. The approach will depend on the terms incorporated and the facts of each individual case, but some of the key issues to be considered include whether there was an express agreement in the bill of lading dealing with the key issue. If not, then was there anything in the incorporated charter party that could be relevant? That first require the incorporating words in the bills of lading to be reviewed. In this case, they were very wide, referring to all terms and conditions, liberties and exceptions. Whether the relevant charter party clause, if prima facie incorporated into the bill of lading, requires a manipulation so as to impose that obligation of the bill of lading holder. For example, by manipulating the clause to reader bill of lading holder in place of the express word or charterer in the clause. if the prima facie answer to A and B are respectively yes and no, as in this case, then the court considered the useful purpose test or looked at another way. What the purpose of the incorporating the clause into the bill of lading was if it imposed no liability on the bill of lading holder. This approach allows the terms of bill of lading to be identified, following which the court moved on to the core issues, namely whether the bills excluded liability on the part of bill of lading holders to pay cargo's contribution in GA in the event the vessel encountered a peril insured under any of the insurance. There was no such clear wording in these bills, hence the appeal was rejected, and thus the common practices in piracy or ransom cases that the holders of the bills of lading are generally liable to make a GA contribution was upheld by the Court of Appeal. It is sources by the Standard Club. It is all the news about the bill of lading and the maritime law problem, because as we can see, not all people were obeying the rules that made by the government. It is very crucial, or it is very not a good thing, or something that I cannot say. It is very dangerous if the people did not have obey the rule, the maritime law, because maritime law is very dangerous. I mean, it is very important because maritime law was not inland, it was on the sea, it was offshore, it was on middle of the ocean, that we knew that there are so small safe place in there, not like in the land, but in the in the middle of ocean. It's very dangerous because most people, there are so many piracy, or maybe people who likes looting things from the ship or boats or vessel, because as we can see, this law is very important for many people, also for the safety for the sailors, because this law was ruled for all people, for the maybe for passengers who doing a trip by the ship, or maybe a sailor, or maybe people who work in the ship, maybe whatever that is. I think it is very important. Maritime law, it is very important for all of us to understanding the maritime law itself, and also implement it in the daily life in the middle of ocean. So thank you for watching, and don't forget to like, comment, and subscribe.